Our next speaker is Erik Nichols, managing partner in the Houston office of Hensley, Fowler, Hepworth, and Schwartz. Erik is an old friend and a frequent speaker. He is bringing us today the information. His topic is Show Me the Money, Recovering Attorney's Fees in School Litigation. Please welcome Erik Nichols.
Thank you all very much. I'm actually pleased and proud to actually say I'm here this afternoon and that there's so many of y'all actually here still this afternoon. Usually when you look at the 4:15, 4:30 slot, and then you've got a beautiful day in Austin, Texas, you're like, I may have a pretty scant audience. But very glad to be here today. Thank you very much for having me. First, I'd like to go ahead and dispel a couple of rumors about the presentation, just so everybody knows. Number one, contrary to request that I've had so far today to do the Jerry Maguire, show me the money up here, I will not be doing that. Number two, for anyone who actually thought this was a way to get more attorney's fees from their clients or otherwise, I also will tell you that is not what the case is actually about. I figured that would probably clear out a few people right there. Number three, can I see a hand show of all the non-attorneys in here right now? Okay, for all the attorneys that made the request, those are the people you need to be looking to. So, anyway, to look at this particular one, and when I looked at the little schedule today, I was also somewhat interested in the fact that this was the ethics presentation as well. Well, in that vein, since only my name is on the presentation, I do have to say two of my associates actually helped me very much write this presentation, just as full disclosure. So nonetheless, there are a couple of things I'd like to talk about as far as this piece of the presentation. Number one, we're not going to go through every possible conceivable part of attorney fee collection that you might be able to for a school district. Obviously, in a 30-minute slot, I will try to make up a little bit of time. I'm not going to hit all of them. What I'm going to try to do is hit some of the high points and some of the different pieces. One of the first ones I want to hit, let's see if I can actually do the clicker correctly here, is this basic fact. Now, one of my clients was so nice to actually tell me this the other day. And I think it probably has some truth there. Now, when we look past that, what are some of the things we want to talk about? Well, the first one I want to talk about is Section 38 of the Civil Practice Remedies Code. Some of you have probably seen this section before. Usually I see it when an attorney that doesn't know school law typically sends it to one of my clients and says, by the way, you owe me attorney's fees. Well, as all of you know in this particular room, there are a lot of reasons that we don't have to pay those attorney's fees. More than likely, unless it's one of the specifically enumerated parts, the district is going to be immune from collection of attorney's fees because they will not be able to present it against them. Now look at a couple of pieces here that we're actually going to talk about, and just a few basics. Number one, the statute actually requires, of course, the party to prevail. The second part is they actually must recover damages. Now those damages can be nominal damages even. We have seen those cases before, and many of you are involved in those cases where the $1 of damages actually is the part. But the part you must also look at is the part of the statute that says individuals or corporations. Well, the AG is defined, in several cases defined, that a school district is not an individual or corporation. So for the most part, Chapter 38 is not going to apply to districts overall. Something that must be said about this point in time, though, is even if you do not have direct contractual liability under Section 38, and we will talk about one little piece of that in a minute, one of the things that's important to look at is some of the other sections of the statute which we know are out there. In the last couple of years, we've seen such things as declaratory judgment actions. Yes, school districts can have attorney's fees assessed against those. Your Public Information Act, which we just had a very good discussion on that as far as the different parts of the AG, those are rabid out there. We've had a couple of papers in the last year that have truly filed suit against school districts and have looked for their attorney's fees based on the failure of the district to actually provide information requested in a Public Information Act request. Remember, those are out there as well. And, of course, don't forget the whistleblower part. One of the things that we actually look at as far as these also, though, is that there are some things which we can waive. Remember, I'm already flipping back across them. There we go. One of the things they must do is actually present a demand to the school district. They must be represented by an attorney. Now, one of the more interesting cases that's popped up in the Fifth Circuit this last year, and they didn't really do a good job of actually looking at it, is whether or not a parent who was also an attorney could actually collect attorney's fees for the representation of their child. Now, there are several circuit courts that have said they cannot. I think that that's probably the appropriate way to look at it because they are not in a representative capacity regardless of whether they're an attorney or not. Now, if they are representing their family or otherwise in something else or someone outside their immediate family, there's some question in the cases they are. But you must be represented by an attorney. You must present a claim, and you must do it in a timely fashion. Now, one of the questions that's come up with this particular part, and I think somebody actually touched on it earlier as well, is what about the construction contracts? You see a lot of provisions now, and we've got all the questions as far as the Tukey case that came up last year, as far as whether or not if you have construction claims that specifically say you are waiving liability and or you're waiving your ability to contest attorney's fees, whether or not you can still assess attorney's fees against the district. Not sure at the present time, and I will say I don't think the cases up there are all that clear at this point in time. But there is some question about whether or not that can be done. The point also is, though, that school districts, as long as they're not suing another municipality or another part of the government, can collect attorney's fees under this particular section. Now, let me flash forward to the civil rights part. Obviously, many of the cases that we see in the area of school law do involve the civil rights aspect. One of the things I think is very important there to always remember, in a prevailing party under civil rights actions, one of the major questions for the court is that the court has discretion. Now, what does that discretion actually mean? Well, it means the court can actually look at the presentation of the material, how the case actually went, and then make a determination on the award of fees. Now, we're going to get to a couple slides ahead, then I'm going to talk about this in a minute. But one of the first things the court is actually going to look at is who was the plaintiff and who was the defendant. Now, why do they do it that way? Well, because they apply different standards on whether or not the party actually asking for fees is plaintiff or defendant. And a lot of this goes back to the nature of the civil rights actions when they started off. Some of the case law even says that attorneys representing a party under one of those sections, under 42 U.S.C., is actually considered a private attorney general. And we're trying to reward them for that type of work because we want to make sure that a violator of federal law is prosecuted. That being said, when you then look at and apply the standards there, they first look at whether or not you're a plaintiff or defendant. Then we look at the question of whether or not the party has actually prevailed. Now, prevailing party status is one of those questions, and we'll talk about it more when we get to special ed, but it's one of those questions about how do you define prevailing party status. Well, for the most part, most of the civil rights questions talk about who actually won, who actually prevailed on the case itself. Not quite that simple when we get to the IDEA, but as far as this, for the basic instance of, say, who actually won the case or who got the case dismissed, as we'll talk about in a sec. Then you've got to look at the question of whether or not there are special circumstances which would show that attorney fees should not be awarded. Now, I never liked that particular part of it because that always tells to me that at that point in time, it's time for me to start praying because that's when you actually have to beg the court not to award attorney's fees because of something you did not or did think you did not do. These are some of the factors, though, that the court can look at that are special circumstances that they will demonstrate does not relate to reward of attorney's fees. And some of the ones that are important there are the windfall issue. The windfall issue is one of the ones that talks about if the attorney's fees for the particular person should be a windfall, then obviously something that we want to present to the court and say that's a reason not to award attorney's fees. Again, if you look at the defendant's financial situation, it's been my experience that usually doesn't work all that well, especially when you're representing municipalities or districts, and that it will be a burden on the taxpayers or otherwise. Some courts are amenable to this, some courts are not. One of the things I think it's also important, I didn't actually put it in the paper and I apologize, is remember to be able to use certain pieces of the Act and certain pieces of the offer letters. Offers of judgment actually can be very helpful in civil rights actions to be able to cut back on some of the attorney's fees we actually have. All right. Now, the interesting thing about it is, regardless of whether or not you prevail as far as the defendant, in other words, if you knocked out the plaintiff's claims, if you've got them dismissed, that does not mean that instead you would be awarded attorney's fees absent special circumstances. It's been the typical of the cases that more likely you will not be awarded attorney's fees. The standard is that much higher. And those of you who have tried these, and I know some of our colleagues in the room here have definitely tried to present over the years reasons for frivolous actions. When you look at frivolous actions, or as we call them frivolous actions, what does that really mean? And you'll see the same language throughout a lot of the materials. Frivolity, which I've never really seen that word, but frivolity as it's considered in the Act, is frivolous, unreasonable, or without foundation. All right, well, what does that mean exactly? Well, it doesn't mean that you won as far as from a defendant's basis. Unfortunately, that's what a lot of us think. And, for those of us who represent school districts all the time, how many of you have actually received a case from your client that they actually thought was not frivolous? It just doesn't happen most of the time. Been very seldom that I've actually seen one. But when you've got to look at the pieces, what the court looks at and what the court will continue to look at as far as a defendant is not necessarily that you got the cases dismissed or the pieces of the case dismissed, but how unreasonable, how frivolous actually the matter really was. Now, if you look at the materials, and we did cite some of the cases and they're attached to the back, most of those cases actually go to the aspect that regardless of whether you got a part or all the case dismissed, you must look instead, and you must literally prove that it, beyond a shadow of doubt, it was frivolous, that it had no foundation, that the only purpose they really brought it for was harassment. Now, the frightening thing is, in looking at some of the cases that are actually attached by some of our colleagues in the room, I would definitely say that most of us, the majority of us in the room, would say some of these cases are frivolous. When you have a pro se plaintiff that has filed 6 actions in 1 year, has cost the district nearly $200,000 in legal fees, but yet was nothing found on any of the cases. At that point in time, the court said, in that particular case, don't do it again. If you do it again, then we may assess you attorney's fees. And that's how a lot of the cases go. I was talking to one of our colleagues before we walked up here, and he made the comment, it's difficult to get the courts to assess attorney's fees against the other parties. You will see it sometimes, but as a defendant, you will not see it very often. The standards are completely different, and the standards are completely different as far as the actions. Okay. How about under Texas law? One of the things that we had changed a few years ago was the section 11161 of the Texas Education Code. A lot of you are familiar with this, and again, you will see the same language that appears there, that it must be unreasonable, without foundation, and it is just so unconscionable that it's not something that you actually be able to present. Special Ed changes a little bit, but if you look at these particular ones, the suit was dismissed or judgment was rendered against that party. Okay. Now, what does that exactly mean? Well, unfortunately, the cases really don't define it all that well. Because, again, what we have is a situation to where most courts are more interested in giving a warning to the parties that have the frivolous claim brought against them, or say, if you do it once more, then we might assess those fees against you. But most of them will not do it. Actually, if you look at the cases that are actually attached, most of them say either a warning or it's such a stiff penalty brought against the person. We don't want to chill litigation brought against a district or municipality. Therefore, we will not actually sanction the action. The interesting thing about this that I think we should look at as well, and there's not a clear case on it, is the prong on number 2. The suit is dismissed or judgment is for the defendant. I think there's a couple of cases out there, and we've had several discussions on this amongst the different groups, is what happens if you have multiple claims and one or two parts of it is actually dismissed, or they were brought purely for harassment or of frivolous nature. Can we get attorney's fees as the counter defendant or as the counter plaintiff against the plaintiff itself as the defendant for the dismissal of those portions of the action? I really, when you look at the different pieces of it, that I think we might be able to persuade a certain court to do that. But there is no case directly on point right now that actually indicates that. The 2 cases that have actually looked at this so far, we actually have attached to the material. One is the Alvin ISD case. The other one is the Edgewood case. I think it's very important when you look at those particular cases to be able to do 2 things. One, if you're in a situation, and I don't mean the typical situation where your client says this case is frivolous, because as we know, that does happen quite a bit. But in a case where you really are seeing an aspect of trying to be harassing to the district, to continue to do things over and over again, I think that's when you actually have to start a paper trail. As far as the plaintiff, one of the things I would make sure, as far as plaintiff attorneys can do, is do everything you can to be able to identify the parts you're actually bringing the suit under, to continue to say, this is why it's not frivolous, and build a paper trail to some extent and point out the particular statutory provisions and the evidence therein as the case goes forward if you start receiving letters from one of the defense attorneys saying it is frivolous. As far as the defendant's side attorney, I think it's also important to develop a trail or develop a way of actually identifying that, look, these particular provisions are frivolous. They don't have any foundation to them whatsoever. I don't understand where you're bringing as far as this particular matter. And we do believe that we're going to be able to get attorney's fees against you at some point in time. I think that's probably the appropriate way to do it, because if you look at how the court's decisions are, most of them say, first warn, then apply penalties later on. I think by doing it that way, either side, you either avoid that situation or you try to build a case that someone is bringing a frivolous action against you. Those are the two cases I was actually referring to. Sorry, I'm on the slide above. Okay. Don't forget, though, either side about the cost provisions. Merely because you cannot necessarily have attorney's fee awarded, don't forget about the other cost provisions under Section 54B. I do believe that the federal rule has some applicability as well, because you can use Texas Rules of Civil Procedure 131 to be able to assess cost. Now, as the rule actually says, recover adversarial cost, except where otherwise precluded. You can look at those particular ones, and again, any type of litigation, as we now know, has a tremendous amount of cost factors behind it. And that's something that, again, if you are the prevailing party in the action, you should be able to assess against the other side. Most courts are more lenient with this particular provision, whether you are the plaintiff or defendant, about assessing them, rather than looking at a counter defense as far as a defendant trying to get attorney's fees for their prevailing status. All right. Now, the last one, and there's not too many of the special education attorneys left in here, and I'm good on time, so I'll just go ahead and go forward on it. One of the things that I think is important for us to look at, and we don't see these cases very often, is some of the changes and some of the abilities under the IDEA. And obviously, those of you know, Individual with Disability Education Act. It's what governs a lot of the things as far as special ed. And one of the things important to this, and a lot of the times why special educations are brought, regardless of what the petitioner's attorneys say, is to be able to establish attorney's fees. Unfortunately, one of the attorneys that brings the majority of the actions in the state of Texas has literally told many of us on several occasions that the only reason he brings the actions is not because of the child, but because he gets his attorney's fees. Now, obviously, as deplorable as that is, it's important to look at how that really comes about. First off, we have the issue of prevailing party again. One of the things that I think is important to look at is prevailing party in a special education case, as far as attorney's fees, does not look like what we would typically find in the other civil actions. I've listed a lot of the factors that actually go into it, and I won't go into each one of them. But I think it's important to look at the most important one in a lot of ways is, number one, the time and labor required for the litigation. One of the things that the federal legislature has said, as well as the federal courts, is that, look, a lot of times these families do not have the money to actually hire an attorney. That's the reason we set up the procedure to start off with, that you have an attorney be able to come in and represent the family and bring it against the school district. In that way, that's one of the reasons for the award of attorney's fees, and to look at the awards in similar cases out there that the attorney may be able to bring. Now, to that end, though, you've got to look at what was the degree of success actually obtained. Not merely that they won on different points. And obviously, many of you have seen these cases. For instance, you may have 5 distinct causes of action in a due process hearing. Say, for instance, though, that the party, the petitioner for the child, only prevailed on 1 out of those 5. Then a bill is presented at the end, and a little bit of structural question is you don't actually present the bill for attorney's fees to the hearing officer. That's later presented to the federal court if you can't actually work it out. So, for instance, the hearing officer actually renders a decision, and the decision shows that the petitioner or child's attorney only prevailed on 1 out of 5 issues. Is that person the prevailing party for purpose of the stat? Well, yes, they are. But the question is, what degree of success did they actually obtain? That's what really impacts the fees. In order to get there, you've got to look at the 2 prongs. Number 1, you must have an altering of the relationship between the district and between the child. And number 2, you must actually foster the purpose of the IDA. In other words, they were doing something which actually assisted in the IDEA and the purposes behind it. Now, the important part of that is what degree of success that actually means. Well, in some of the cases that have actually talked about it, structure it this way. If the only issue that was prevailed upon was not the issue the attorney spent the majority of his time on in working for the family, then that's not what their recovery of fees is actually going to be based on. For instance, if you have the 1 of 5 issues again, but the majority of the attorney's time was spent on the other 4 issues, then that obviously drops the fee amount down dramatically. And that's something that we can actually present. If you have a situation such as the one we have on the board here, that the child only prevailed on 3 out of the 19 issues presented to the hearing officer, that obviously cuts down the amount of relief dramatically. And that's what we try to demonstrate to the federal court if it actually gets there. Now, in that end, does that mean, though, that they didn't prevail? Well, no, it doesn't mean they didn't prevail. It just means that their fees would be dramatically reduced. Okay. Now, under the changes into the Act, and some of you probably know, or most of you probably know, the IDEA was reauthorized in 2004. Went into effect in the summer of 2005. One of the provisions that was requested out there, and one of the things that Congress put in because of the complaints that were there, was when can we go back after the parent attorneys for all these frivolous actions? When can we get attorney's fees? Well, guess what? It's in the new Act. Now, the language, as you'll look in the second paragraph there, is very, very similar to what you'll find under the federal claims provision, that again, it's unreasonable, frivolous, or without foundation. Now, at this writing of this paper, and as we did a little research just the other day, we have not found a single district under this provision that's been able to recover their attorney's fees against a petitioner's family. I would imagine that the uphill on this is going to be quite dramatic because, again, the courts are not going to want to chill the ability for the parents to actually bring a cause of action against a district. It's just not going to happen. So I think that you have to look at only the most blatant cases are going to have this particular type of effect. And I don't think that those are going to happen very often. Okay. How do you actually do it? We talked about it a little bit. You have to look at the aspect of whether or not the attorney actually presented the information, whether or not they prevailed on it, and whether or not it altered the relationship in between the district and the child. If they do not actually qualify for that, they are not a prevailing party. But as we indicated, even if they prevail on 1 out of a certain number of issues, they still could be a prevailing party. But just remember again, it actually cuts down on the amount of fees. Well, and at this point in time, since we're trying to catch back up, and since I think that was my allotted time, I thank you all very much for your time and attention, and I'll conclude.